report presented to Cabinet yesterday. Geoffrey Shannon, the Special Rapporteur for Child Protection, he's the man charged with advising the government on protecting children, recommended a change in the law to allow anybody concerned about the welfare of a child to apply to court to have the child put into care. He said the proposal would only apply in exceptional circumstances to children already known to child services. For more on this, let's speak to Tanya Ward, Chief Executive of the Children's Rights Alliance. Tanya, thank you very much for coming in to us. What do you make of this proposal?
Well, we would think it's a possible check against the HSE failing to act. Because if you look at child protection cases at the moment and how they're run, if you make a report to the HSE, it's really up to them to act. So they'll assess a case, they might decide to provide some support, or they might decide to go to court and seek an order. But if the HSE, let's say, and this is what the report says, in some circumstances the HSE might assess a case, might decide there isn't a risk, or they mightn't actually get to the case. That can happen as well. Shannon is suggesting that there should be a possibility for people who are concerned where there are child protection issues, that the court, you should be able to make an application to district court to empower people to seek the HSE to act in that case.
He makes the point in the report it's the HSE alone that polices the safety and welfare of children in Ireland. The question must be asked, is this sufficient? He seems to be answering it as well in his proposal that it's not.
Indeed. I mean, the only option that people would have would be to seek judicial review proceedings at the High Court. That's a very difficult thing to do. There was a case where a grandparent did seek an order for the HSE to act, but they had to get a solicitor, they had to get a junior counsel, they had to get a senior counsel, and there's always the fear if you go to the High Court of having costs awarded against you.
And it takes a while. It's the expense and the time delay, and meanwhile, if those concerns were genuine, the child remains at risk. That's
it exactly. And if you look at the child death report, there are some children there where the families are really worried about the child. The HSE wasn't acting. This would have empowered them to seek an order for the HSE to act.
This is just a recommendation from Geoffrey Shannon. Is there any suggestion from the Minister's response yesterday, in your view, that she's minded to act on this recommendation?
I didn't pick that up yet, and to be honest, it's a very new recommendation, and it did take us by surprise as well. But we definitely see the merit in such an approach. It might have prevented, or it might have resulted in, let's say, the HSE having to act earlier in the Roscommon case. If you talk to people in Roscommon, there was huge concerns in the area about that family, and this might have been something that might have made a difference.
Geoffrey Shannon does point out in the report the obvious concern. The proposal may well meet resistance on the grounds of it being excessively broad and thereby encourage nuisance applications to come before the courts. He's got a point, doesn't he?
Well, he does have a point, and certainly what you wouldn't want is wide-scale people trying to make complaints against families where they see there are problems. So,
or within families.
Indeed, but I think what he does recommend is that it should only be in exceptional circumstances and where there were real grounds or real reasons where there's a problem in that family.
All of this comes under the banner, and I know this is simplistic, about interfering with the family's rights over children, and this could become a very dominant issue if and when we have a children's referendum. The Minister yesterday on receiving this report reminded us that it was the government's commitment to have that referendum this year, but as the Dáil session has closed, yesterday was the last Cabinet meeting before September, no wording and no date. Are you convinced that we will have a referendum this year?
I am, and certainly, you know, the Minister for Children and Youth Affairs, the Taoiseach, the Taoiseach, they've all committed themselves to holding a referendum this year. So I can't see it not happening. But I think the important thing to point out, you mentioned that maybe this is a threat to the family. This referendum is not about changing the definition of the family in the Constitution. That's not going to be part of that. So the Constitution already says that the state should protect the married family from attack. That's not going to change in this referendum. It's not a radical referendum. It's just going to be about making children visible in the Constitution and ensuring that the courts make better decisions.
Well, that's what we think it is. We've no wording yet to know for sure. Are you concerned by that?
Well, we'd like to see obviously the wording as soon as possible, but the wording that they've been using is recommendations from Area Works Committee from 2010, and that's what that wording was about.
Robert Troy from FINA Fall, who we'll be speaking to later in the programme, says he's disturbed by the delay in the issuance of this report, that it was ready 6 months ago and now it's only being published. What do you think of that? Do you find it disturbing?
Well, I do think it takes some time to respond to reports when they come in. Obviously, you'd like to see it sooner, but in the meantime, they have put a lot of different measures in place. They introduced draft legislation for mandatory reporting, introduced a task force report to establish the new Child and Family Support Agency. So I suppose there's a lot of measures that they focused on introducing before publishing the report.
Tanya Ward from the Children's Rights Alliance, thank you very much for coming into us.